Today's video feature is a complete breakdown of the entire process in a workers' compensation claim. Now, at the end of this video, and it will be rather long, you will have a full and complete idea of what to expect and what you're facing. We're going to address it from both an accepted claim and a denied claim. So let's get started. The first thing that happens is after you're injured, you may reach out to a lawyer. If you call my firm, I'm going to ask you some specific questions. What I'm going to ask for is what was the date that you were injured? What time were you injured? What happened? What caused you to have the accident? What body parts were affected? Did you report it to a supervisor, and when? Did the employer offer you some initial medical treatment? And if not, did you seek initial medical treatment? And when you did get to the doctor, did you fully describe the accident and how it happened on the job? Now, at that point, we'll go over a little bit more of what to expect and how our fees work. And then if you decide to hire us, then we'll get started. Now, in a relatively fresh accident case, the insurance company will oftentimes reach out to you wanting to do something called a recorded statement. Now, there are several views on recorded statements, but as a former insurance defense lawyer, I know the adjuster has to complete their investigation before they can make a decision on whether to accept or to deny a claim, and I don't want to impede or slow down that process. So I'm happy to make you available for a recorded statement. I just want to be involved in the process to make sure that the questions are fair, not misleading, not argumentative, and the investigation is being conducted in good faith and appropriately. Now, after you give your recorded statement, the adjuster will go back and talk with any witnesses and or your supervisor, and then they will give us a decision on accepting liability or not. Now, if they accept liability, we'll go down this path first. Then they will tell you which doctors to go to. We will keep in touch with you as you progress through treatment. Certainly every time you see the doctor, I'd like for you to contact me so that we can go over what was said and what was done and what's being recommended. I also encourage clients every single time you see the doctor to give a full description of all symptoms to all body parts so that there is a consistent record of the nature and scope of your injuries. Now, at some point, the doctor will say that you've reached maximum medical improvement. We've done videos on that as well, but that has both legal and medical significance. Medically, it means that you are as good as they can make you, and legally, it means that we go from treatment to negotiating your case, either by settlement or by a hearing. Now, once we get the doctor's final medical reports, we have permanent restrictions, impairment ratings, things like that, then I'll attempt to negotiate with the adjuster, and I'll get the adjuster to the highest value they're willing to pay voluntarily. And then you and I will sit down and go over that number and make a determination on whether we think it's a good idea or a bad idea to go forward with a hearing. Now, how do I make that determination or recommendation? I base it on what I think a hearing commissioner will do. Just like in other personal injury cases, I base my advice on what I think a jury would do. Now, in workers' comp, of course, you don't get a jury, you get a hearing commissioner. Now, if we can reach a settlement, that's great. There are two ways to settle a case, either a Form 16 basis, which is where you settle for something closer to the rating, but you are able to hold the record open for up to 1 year in South Carolina, up to 2 years in North Carolina, such that if you have additional problems, and what I mean by that is you have a physical change for the worse, physical change of condition for the worse, then you can go back and seek additional benefits, including additional medical treatment. Otherwise, if it's a case where you no longer work for the employer, then it's probably to your best advantage to settle on a full release or something called a clincher agreement. That's where you get paid a little bit more and they essentially buy out the 1 year or the 2 year in North Carolina. So 1 year in South Carolina, 2 years in North Carolina. Now, if we're not able to reach a settlement agreement that's satisfactory, and of course you as the client makes the decision on something like that because it is your case and your life, I'm here to guide you, and I certainly will. I'll answer your questions, explain the pros and the cons, but it is your decision always, and you will never feel pressure from me either way. Now, if we don't reach settlement, then we will set it for a hearing. Most likely at that point, a defense lawyer will be assigned to your case, and they'll want to come take your deposition. It'll be very similar to the previous recorded statement, although this one is under oath and it is being recorded for posterity. And if you lie in a deposition, that is the same as lying in open court, subject to penalty of perjury. Now, my clients never have to worry about that because, frankly, if I thought you were lying, I wouldn't take your case. So my clients have nothing to hide, and they are there to provide full answers so that we can move the case forward. After the deposition, I may need to take some depositions. It just depends on each case. Sometimes the doctors will be deposed, but by the time we go to a hearing in workers' compensation, everything has been done. And we submit records, we submit videos, and we submit all the evidence at the hearing so that by the time the hearing commissioner hears your case, all we are there for is testimony. Now, in an accepted case, we will briefly go over the accident and what happened, which body parts were affected. That's all part of the record. Also, we will briefly skim over the medical treatment because, again, all of your medical records have been submitted, including any depositions of the doctors. What we will focus on at that hearing is the extent of your permanent impairment or injury, how the injury has affected you now, how it's going to affect you in the future, the type of symptoms you continue to suffer from, the types of medications you're required to take to alleviate pain or other limitations. That's basically the gist of the hearing, is to determine how have you been affected and how will you can continue to be affected for the rest of your life. After the hearing, the commissioner will take everything under advisement. They will review all the medical records and any depositions, and then they will render a decision on disability. Now remember, doctors, and we've talked about this in other videos, will render an impairment rating. That is simply one factor that the commission uses. They also include age, education, work history, permanent restrictions, future medical care needs, and so forth to come up with a disability award. They do not award a dollar amount. Instead, they award a percentage of disability. And then the percentage of disability times the value of the body part times your compensation rate is how we get to the actual dollar figure. Okay, that is in an accepted case. Now, if they take the recorded statement, compare what you've said with witnesses and supervisors, and come back and deny your case, then we just simply go straight to litigation. We request a hearing. Hearings come up in South Carolina in about 3 to 4 months. And during that time, there will be extensive discovery. Again, your deposition will be taken by the defense lawyer, and then I will need to take depositions of witnesses and other people to establish that you actually were injured and that you did report it. Then we'll go to a hearing, and it's the same as we just discussed. We'll present our evidence. The defense will present theirs. Of course, in that situation, the burden of proof is on us to show that you were injured within the course and scope of your employment and that it should be awarded as a compensable claim. We'll put you up, and this time we'll have a lot more emphasis on the accident and exactly what happened and exactly who you reported it to. And then we'll move into medical treatment. Again, we'll skim over that because the medical records are put into the evidence. And at that point, you may or may not be under doctor's care, so we may not be able to address any permanency issues at that point. We may have to come back for a second hearing down the road when we get to that point in your medical treatment after being released from care. Now, this is a lot of information. I understand that. I wanted to give you a brief summary of what to expect. Certainly, if you have additional questions, feel free to reach out to me directly. My name is Robert Reeves. My mobile number is 704-351-7979, or email me robert@rjrlaw.com. Hope it helps.